The NASCAR world has been rocked by an escalating legal battle that threatens the entire charter system. Front Row Motorsports and 23XI Racing find themselves locked in fierce combat with NASCAR over their right to compete as chartered teams in the 2025 Cup Series. What began as a dispute over contract terms has exploded into a full-blown antitrust case with potentially massive ramifications for the sport's future. NASCAR's charter system, first established in 2016, fundamentally changed how teams operate in America's premier stock car racing series. The system essentially created a franchise model, similar to other professional sports leagues. Cup teams with charters gained guaranteed entry into each race and secured a portion of each race's purse. This system was designed to provide stability for teams, creating what NASCAR hoped would be a rising tide that lifts all boats. The charter agreement has been extended twice since its inception. The most recent extension runs for 7 years to align with NASCAR's current media rights deal. This extension guarantees 36 of the 40 spots in each week's field to charter-holding teams, along with various financial incentives that are critical to team operations and sustainability. The conflict began in September 2024 when NASCAR presented teams with a new charter agreement. Teams were given just 48 hours to accept this take-it-or-leave-it offer before the playoffs began. While 13 of the 15 NASCAR Cup Series teams eventually agreed to the new charter deal, Front Row Motorsports and Michael Jordan's 23XI Racing refused to sign. The updated agreement did offer some concessions. Charter holders would receive 49% of broadcast revenue under the new media rights agreement, representing a significant 25% increase from the 2016 agreement. However, the teams wanted more. A key sticking point was the demand for permanent charters, which NASCAR refused to grant. Under the current system, NASCAR maintains the right to revoke charters from underperforming teams or even eliminate the system entirely. In October 2024, FRM and 23XI took dramatic action by suing NASCAR, claiming it operates as a monopoly. They also filed an injunction seeking to compete as charter members under the 2025 agreement, arguing that without charter status, they would face an irreparable business collapse while the litigation proceeded. In December 2024, a federal judge granted the teams their injunction, ruling that NASCAR must allow FRM and 23XI to compete as chartered teams throughout the 2025 season. NASCAR didn't take this lying down. During Daytona 500 week in February 2025, they filed an appeal of the injunction, claiming the judge's orders flout federal antitrust law, misapply the established rules governing the use of preliminary injunctions, and have sweeping implications for NASCAR's 2025 Cup Series season. Then on March 5, 2025, NASCAR dramatically escalated the conflict by filing counterclaims against the teams. Notably, they also named Curtis Polk, Michael Jordan's longtime business manager and 23XI co-owner, as a defendant. NASCAR made it abundantly clear that no settlement would be forthcoming. Most recently, on March 14, 2025, FRM and 23XI filed their response to NASCAR's appeal. The gloves truly came off as they called NASCAR's arguments narrow and meritless, accusing the sanctioning body of using overblown rhetoric and hyperbole to attack the district court's decision. Team's response to NASCAR filing. NASCAR's counterclaim pulled no punches. The 30-page filing alleged that 23XI and FRM had willfully violated antitrust laws by orchestrating anti-competitive collective conduct regarding the 2025 charter agreements. NASCAR specifically targeted Curtis Polk, calling him the ringleader against the charter proposals. NASCAR attorney Christopher Yates told the Associated Press that Polk does not understand the NASCAR business model. Yates claimed Curtis Polk basically orchestrated and threatened a boycott of one of the qualifying races for a major event, and others did not go along with him. He got other teams to boycott a meeting that was required by the charter. When you have a threatened boycott of qualifying races that are covered by media, that's not a good thing for other race teams. Not a good thing when you are trying to collectively grow the sport. The qualifying race in question was the 2024 pair of 150-mile duels that set the field for the Daytona 500. Yates didn't stop there, delivering a personal critique of Polk's approach, saying, "I don't think Mr. Polk really understands the sport. I think he came into it and his view is it should be much more like the NBA or other league sports. But it's not. No motorsport is like that. He's done a lot of things that might work in the NBA or might be okay in the NBA, but just are not appropriate in NASCAR. In perhaps the most shocking development, NASCAR has threatened to completely dismantle the charter system if they lose this case. There's a misperception out there that somehow 23XI and Front Row might achieve something that other teams can take advantage of, and that's just not right, Yates told the AP. This is not going to be a renegotiation. NASCAR has no intent of renegotiating the terms of the charter. Front Row and 23XI are threatening the charter system and its continuation, and NASCAR is fine without the charter system. He added, the charter system was created at the request of the teams. That was before 23XI and Curtis Polk's time. I don't think they understand that history, but if they succeed with their lawsuit and the charter system goes away, that's okay. The counterclaim seeks to have the 4 combined charters held by 23XI and Front Row returned to NASCAR. This would effectively strip these organizations of their guaranteed race entries and revenue shares. Front Row Motorsports and 23XI Racing didn't take these accusations lying down. In their March 14th response, they accused NASCAR of using overblown rhetoric and hyperbole to attack the district court's reasoning. They assert that the judge did not understand antitrust law and abused his discretion, the team stated in their filing. But the errors defendants identify are not errors at all. The district court applied well-established precedent to the extensive fact and expert record, properly exercising its discretion to grant a narrowly tailored preliminary injunction that protects the rights of all parties and the public until trial. Each of the defendants' arguments against this narrow injunction is meritless. The teams have maintained their position that NASCAR operates as a monopoly, or more specifically, a monopsony, a market where there is only one buyer for multiple sellers. They detailed how NASCAR maintains its monopolistic control through several mechanisms, acquiring premier racetracks and refusing to grant other stock car races access to these necessary resources, contractually forbidding Cup Series racetracks that NASCAR doesn't own from hosting other stock car races, acquiring its closest rival to prevent it from growing into a competitor, forbidding chartered teams from competing in other stock car races or owning shares in any competitor, requiring chartered teams to use expensive next-gen cars that cannot be used in competing stock car races, imposing a release clause that would bar teams from pursuing antitrust claims against NASCAR. The team specifically highlighted the release clause in the charter document, which reads, "Team owner hereby releases and forever discharges from all arising out of or relating to the criteria used by to determine whether or not to enter into or to offer to enter into a charter member agreement with the team owner or any other person." According to the filing, similar language appeared on entry blanks for non-chartered participants in Cup Series races. NASCAR only removed this language on November 15th after the lawsuit was filed. The team's attorney, Jeffrey Kessler, issued a statement calling NASCAR's counterclaim a meritless distraction and a desperate attempt to shift attention away from its own unlawful monopolistic actions. Kessler stated, NASCAR agreed to the joint negotiations that they now attack. When those joint negotiations failed, they used individual negotiations to impose their charter terms, which most of the teams decided they had no choice but to accept. The teams have made a compelling case for why competing without charters would cause them irreparable harm. In their Friday response, they detailed the potential consequences. Driver Tyler Reddick gave notice under his agreement that 23XY had 30 days to assure him that he would drive a chartered car in 2025. Driver Bubba Wallace said he needed to know immediately how 23XI intended to compete so he could explore opportunities with other teams. Driver Corey Heim did the same, telling 23XI he needed answers right away so that he could speak with other Cup race teams to see if any other opportunities would exist. The sponsor situation looks equally dire. A major 23XI sponsor revoked one promotion and rescinded an opportunity for a multi-year deal because it was scared that both could miss the Daytona 500 that Reddick will leave the team at the end of 2024. and a key sponsor informed Front Row that it was evaluating options to reduce, eliminate, or redirect financial commitments given the uncertainty over charter status. One sponsor was particularly blunt: if you don't qualify or are not allowed to race in the Daytona 500, it will be a breach of our agreement. The Daytona 500 is not a race you can remedy us. In their brief, the teams wrote that the charters provide the teams with much less revenue and less favorable terms than would prevail in a market unrestrained by NASCAR's unlawful monopsony. Teams do not have a fair opportunity to earn a return on their investments tens of millions of dollars each year.